What is up? Good morning and welcome to the Transparency. Today is Thursday. Thursday all day. Yep. Come on, let's go. Let's rock this. We're going to talk about the Delphi case. We're going to talk about how the state is trying to get a record going. They're trying to get things on the record. Filings of motions. Specifically, they want Baldwin and Rozzi to be held in contempt. Also, they are requesting discovery. That this whole process, there was a discovery deadline November 1st, 2023. The defense has not turned over one single piece of discovery to the state to include any expert witnesses, any witnesses, period, numbers, addresses, who they intend to call, any memos, again, experts, findings, maybe a false confession expert. But let's talk about it. Let's do it. Here we go. Hello and welcome to Truth and Transparency. Good afternoon. Welcome to the Transparency. Welcome to Truth and Transparency. Not sure if this is working,
but today is not a day to celebrate. With the arrest of Richard M. Allen of Delphi.
Take care, Miss Vargas. See you soon, Miss Vargas.
Paparazzi, stop.
All right, guys, let's do it. Take a look here. I'm just going to hit the most important parts right here. This is where that was the deadline, November 1st, 2023. So again, the state is saying, hey, we want the defense to give us the following, which is, who do you plan on calling as a witness? We need those names because we're going to depose everybody. So again, a shout out to defense diaries, but right here, that the state intends to depose all defense expert witnesses and or other witnesses in preparation for pretrial hearings and jury trial, but cannot do so without full discovery disclosure as required by the rules. So this was filed, filed 1/27, 2024. But throughout the case, they were supposed to be exchanging information back and forth. The state says, hey, we've turned over everything. It's now, hey, the defense has given us nothing. So we need whoever they're calling. Okay. And this is part of the rules in court. So yes. And they want this to all be turned over within the 30 days. But the big thing is that this was the deadline before everything went cray-cray. And they're saying that they haven't received anything from the defense. Again, they are starting this record. All right. I could sit here and read everything, but it's very brief, very simple, straightforward, that to date, the defense has neither turned over any discovery nor have they provided the state with a list of expert witnesses that they intend to call at trial or at any other pretrial hearing. That despite requests by the state for defense disclosures, any exhibits they intend to use in depositions, defense has failed to provide the state with those exhibits prior to the commencement of depositions thus far. So again, this is the state asking Judge Gall to come on in and say, hey, they need to comply with the rules. Okay. Again, this is what they are claiming. Now, if the defense is saying, we're going to just use all of your witnesses against you, so we'll see. We'll see how that plays out. Here we go. This is the state saying, again, they want this record. And here it goes. Nick is saying that you're going to hold Baldwin and Rossi in contempt for all of their actions thus far. Like, what's going on? In brief, he goes through a timeline of everything that has occurred. We've all heard that right here. This is where he says it, swearing under the penalties of perjury, blah, blah, blah. But he wants to know, the state asks that the court issue a rule to show cause order based on this information and set this matter for a hearing and order attorneys Brad and Andrew Baldwin to appear and show cause, if there be any, why they should not be held in contempt by this court. So they want a hearing. They want to talk about this. Nick is like, they should be in contempt of court. Now, some people might not remember, might have never seen, this is the press release that they said was way over, way extra, should have never happened. This was before a gag order. Okay. And so I want to touch base on this press release and let's truly see how awful it is. All right. This was in response to all of the press was wanting them to comment. Hey, what do you have to say? Hey, what do you have to say? So their response was, we can't possibly take all of your requests to local and national media for interviews and comments since the unsealing of the probable cause affidavit. It would be virtually impossible to comply with those requests and continue to focus on the merits of Rick's defense. Therefore, we just offer up these thoughts. We do not want to try this case in the media. Oopsies. I'm going to go ahead and zoom in, though. We do not want to try this case in the media, and we intend to adhere to the Indiana rules of professional conduct. However, the police and prosecutor's office have conducted many press conferences over the 5+ years of this investigation and following our client's arrest. On the other hand, Rick's ability to assert his innocence has been reduced to only one short post-hearing press conference. Accordingly, we feel it appropriate, necessary, and within the bounds of our rules of professional conduct. So right there, they feel this is within the rules. So they are addressing that right off the rip. And they want to make a few comments concerning the probable cause affidavit and Rick's innocence. Okay. So this is just to do with the probable cause, and they are having their clients back just to say, and Rick's innocence. Rick is a 50-year-old man who has never been arrested nor accused of any crime in his entire life. He is innocent and completely confused as to why he has been charged with these crimes. They said this out the gate before they ever got a single piece of discovery. You understand that? These lawyers said this before they ever got anything. This was just right after the probable cause was unsealed, and there was no gag order, and everybody was wanting them to talk to local and national media. This is how they went about it. The police did not contact Rick after Libby German and Abby Williams went missing. Rather, Rick contacted the police and voluntarily discussed being on the trail that day. Like many people in Delphi, Rick wanted to help any way he could. Rick contacted the police to let them know that he had walked on the trail that day, as he often did. Without Rick coming forward, the police probably would not have had any way of knowing that he was on the trail that day. Rick volunteered to meet with this conservation officer outside of a local grocery store to offer up details to his trip to the trail on the day in question. Rick tried to assist with the investigation and told the police that he did recall seeing 3 younger girls on the trail that day. His contact with the girls was brief and of little significance. Rick does not recall if this interaction with that officer was tape recorded, but believes that the officer scribbled notes on a notepad as Rick spoke to him. Again, this is just refreshing us all of what this press release was all about. After Rick shared his information with law enforcement officials, he went back to his job at the local CVS and did not hear from the police for more than 5 years. The next time Rick heard from the police was in October of 2022. This was approximately 2 weeks before a contested sheriff's election and within days of a federal lawsuit filed against the Carroll County Sheriff's Office by its former second-in-command, Michael Thomas. We're going to get into that because I'm going to do some digging on that. Everybody just talks about the sheriff race election. How about this? In the lawsuit, Thomas claims that Thomas, had made suggestions and offered assistance in the investigation of a high-profile child homicide investigation, but those suggestions and offers were rejected by the sheriff. Thomas further claimed that the sheriff and others in the department feared the disagreements with Thomas would become publicized as a result of the political campaign for sheriff. Thomas claims in the suit that he was ultimately demoted and replaced by Tony Liggett, who later that year won the 2022 election for sheriff. Furthermore, Thomas claims that he was also removed from high-profile cases. Rick was ultimately arrested on or about October 28th. In the 5+ years since Rick volunteered to provide information to the police, Rick did not get rid of his vehicle. I think that's huge. His guns, okay, and did not throw out his clothing. He did not alter his appearance. He did not relocate himself to another community. He did what any innocent man would do and continued with his normal routine. The probable cause affidavit seems to suggest that a single magic bullet is proof of Rick's guilt. And the thing that I've been talking about recently is, why wasn't this bullet ever talked about in the Ron Logan case, in the Ron Logan probable cause? The first time that we hear of this is with Mr. Allen, and I find that hard to believe. A case should be, it is what it is. If that was there, then that should have been something that would be talked about on anybody's probable cause, right? Again, welcome everybody to the Transparency. Make yourself known. At some point, you're going to have an opinion about the video. Thumbs up, thumbs down. You have an opinion. Also, you feel free to use the comment section of the video as well as live chat if you are live with us right now. A good morning to all the members, subscribers, lurkers. So yeah. So that single magic bullet is proof of Rick's guilt. It is a bit premature to engage in any detailed discussions regarding the veracity of this evidence until more discovery is received. But it is safe to say that the discipline of tool mark identification ballistics is anything but a science. The entire discipline has been under attack in courtrooms across the country as being unreliable and lacking any scientific validity. We anticipate a vigorous legal and factual challenge to any claims by the prosecution as to the reliability of its conclusions concerning the single magic bullet. When I think of single magic bullet, you guys don't even want to know what I'm thinking about. Good morning. On Rick's behalf, we argued to have the PCA unsealed. Okay. Transparency. They did that. We argued to have that unsealed. Rick has nothing to hide. As importantly, we were hoping that we would receive tips that would assist us in proving his innocence. Not surprisingly, we have been inundated with tips from a variety of sources, all of which will be vetted by our team. Although it is the burden of the prosecutor to prove Rick's guilt beyond a reasonable doubt, the defense team looks forward to conducting its own investigation. And that's exactly what they did. Everything that they wrote in this little press release, okay, they did it. They did it. They stood by their word. They said exactly what they were going to do. So not only is it their burden to prove all this, but guess what? We're not going to just sit back. We're going to conduct our own investigation concerning Rick's innocence. We appreciate those that have reached out to support his cause. The prosecutor mentioned at the last hearing his belief that others may have been involved in the killing, yet there was no mention in the PCA about a second suspect involved in the killing. The defense is confused by such discrepancies within the investigation and will be in a better position to respond as more discovery is received. So again, they were expecting that they could be responding in some capacity to this part of it, but never got that opportunity because of the gag order. Rick Allen owned a Ford Focus in February of 2017. His Ford Focus is not in any way similar to the distinctive look of the PT Cruiser or smart car that was described by the witnesses. Now, check this out. At the time, they did not know this, but now you're going to mix into the fact that they're lying about what the witnesses said, but they didn't even know this at the time. Okay. It seems that CCSD is trying to bend facts to fit their narrative. Carroll County Sheriff's Department, that is. At this point in time, we have received very limited information about this case and look forward to having something more to view than that which was offered up in the sparse PCA. Moving forward, it is our intent to scrutinize the discovery as it is received and give the necessary attention to the volumes of tips that we are receiving. So they're making it known that, people are in contact with them. To the extent we continue to discover information that points to Rick's innocence, we will offer up this information to the public, so long as we are not prohibited from doing so as a result of the recent request by the prosecutor for a gag order or by the Indiana Rules of Professional Conduct. Now, this was their exhibit. This is, when I say their exhibit, the state's exhibit, when they want this contempt on, again, they're just trying to make a record now, having things on the record. We have to have a hearing for this. This has to be, done the right way. So they're creating this record. Again, this was just filed 129. And they offer up one exhibit, and that this press release was in fact that one state's exhibit for this filing. But that's all that was said. Okay. That is all that was said in that press release. And I'm over here like, what in the world is so bad about that? What in the world is so bad about that press release? And the answer is absolutely nothing. If that's a problem, then we all as citizens of the United States of America, when facing anything that would require us to have a lawyer, okay, as a defendant, we have a lawyer. If that's a problem, somebody wanting to do their job for us, then that's a problem. That's a problem for us as a whole, as anybody that's walking in the United States of America right now, that they think that is a problem. Again, in this in this outline for contempt, it goes literally in chronological order of things that they deemed like this is what they've done. This is what they've done. Everything that we've heard. That's why I'm not going to repeat any of this. That the press release contained multiple comments of the kind presumed to have a substantial likelihood of materially prejudicing how there's no information. There is no information to prejudice. Like what? How can we prejudice anybody? We don't have anything. We have a probable cause that is public. Let's see, number 4. That on December 1st, 2022, the defense put out a press release that included extrajudicial statements by means of public communication that commented on the case to the public and to the media, including commenting on the investigation by law enforcement, the evidence discovered against the defendant, and presenting evidence that they believe proves the defendant's innocence. Oh, shit. What? Okay. The information release would have been in direct violation of the gag order that the defense would not agree to, and which the defense stated was unnecessary because they were not going to discuss this case in the public or the media. The press release is herein attached as State's Exhibit 1. So this would have been in violation had there been one, is what they're saying. Let's play devil's advocate. This is Tina with What the Fuck Translation Services. Rick is a 50-year-old man who has never been arrested nor accused of any crime in his entire life. This is a factual statement, so we'll highlight everything that's facts. He is innocent and completely confused as to why he has been charged with these crimes. Okay. The police did not contact Rick after Libby and Abby went missing. Rather, Rick contacted them. Yep, that's a fact. Like many people in Delphi, Rick wanted to help any way he could. Okay, I think there's no problem with that sentence. Rick contacted the police to let them know that he had walked on the trail that day, as he often did. Isn't that in the probable cause? Without Rick coming forward, the police probably would not have had any way of knowing that he was on the trail that day. Rick volunteered to meet with an officer outside of the local grocery store to offer up details. That's just a fact. Rick tried to assist with the investigation and told the police that he did recall seeing 3 younger girls on the trail that day. That's in the probable cause. His contact with the girls was brief and a little of significance. That's in the probable cause. Rick does not recall if this interaction with the officer was tape recorded, but believes that the officer scribbled notes on a notepad. What the? Okay. It's playing a game here. After Rick shared his information with law enforcement officials, he went back to his job at the local CVS. Okay, is that fact? That's fact. Okay, another fact. The next time Rick heard from the police was in October. Fact. This was approximately 2 weeks before. Okay, they're giving a date. This is all fact. In a lawsuit, Thomas claims that he, Thomas, had made suggestions and offered assistance in the investigation of a high-profile child homicide investigation. In the lawsuit, so they're getting this from a lawsuit on the record. Those suggestions offered was rejected by the sheriff. Thomas further claimed that the sheriff and others in the department feared the disagreements with Thomas would become publicized as a result of the political campaign for sheriff. Again, this is all in the lawsuit. But if you want to leave maybe this portion out, you could have, I guess, but it's not. I mean, it's in a lawsuit. It's Thomas claims in the suit that he was ultimately demoted and replaced by Tony Liggett. Okay. It's in a lawsuit. Who later won sheriff. Okay, that's fact. Furthermore, Thomas claims that he was also removed from high-profile cases. It's all in a lawsuit. Rick was ultimately arrested on, okay, fact. In the 5+ years since he volunteered to provide information to the police, Rick did not get rid of his vehicle, guns. Okay, fact. He did not alter his appearance. He did not relocate himself to another community. He did what any innocent man would do and continued with his normal routine. The probable cause affidavit seems to suggest that a single magic bullet is proof of Rick's guilt. That's in the probable cause. The probable cause affidavit seems to suggest that a single magic bullet is proof of Rick's guilt. It is a bit premature to engage in any detailed discussion. So they're saying we're not going to talk about that. It is premature. And then, but it is safe to say that the discipline of tool mark identification ballistics is anything but a science. On Rick's behalf, we argued to have the PCA unsealed. Those were his wishes. Rick has nothing to hide. As importantly, we were hoping that we would receive tips that would assist us improving up his innocence. Not surprisingly, we have been inundated with tips, so a lot of people are turning stuff in. Although it is the burden of the prosecutor to prove Rick's guilt beyond a reasonable doubt, the defense team looks forward to conducting its own investigation concerning Rick's innocence. We appreciate those that reach out. The prosecutor mentioned at the last hearing his belief that others may have been involved in the killings. So they're repeating what the prosecutor said. Yet there was no mention in the PCA about a second suspect involved in the killing. The defense is confused by such discrepancies in the investigation and will be in a better position to respond as more discovery is received. Rick Allen owns a Ford Focus. Fact. His Ford Focus is not similar to the PT Cruiser or a smart car. It seems as Carroll County is trying to bend facts to fit their narrative. Right there. That's their opinion right there. It seems that Carroll County Sheriff's Department is bending facts to fit their narrative. And here they would be correct when you have witnesses that said that we didn't say that. That's not what we said. Like, that's why was a Frank's hearing motion that was offered up. At this point in time, we have received very limited information about the case and look forward to having something more to view than that, which we can offer. So if this is a problem, okay, if this is a problem, and if this is seen in, that this should be, that these actions should hold a lawyer in contempt during a huge, highly publicized double murder of 2 little girls, then, like I said, America as a whole, we are in trouble. Okay. But this is them, I believe, just putting this all on record. Okay. Check this out. You know how Nick McLeland was saying that he was up for, all these hours investigating this leak? Take a look. That investigators attempted to interview both Mitch and Robert, each of which declined. That shortly after investigators attempted to interview Robert, he took his own life. An investigation into that death is what led law enforcement to find out that shortly before his death, he had expressed concerns about the open investigation concerning the discovery leak in this case and stated to someone that if he just came clean, all of this would go away. And that someone we're basically saying is his wife. So they're basically saying in this that they never had the opportunity to interview Mitch or Robert, that they never talked to him. They declined to be interviewed. And that shortly after investigators attempted to interview Robert, so they're basically saying, we never even got to speak to him. We attempted to interview and he declined, that, he took his own life. Now that's interesting to me because that's not what I've been told. Now, right here, there was then a search warrant on the iCloud account of Mitch, and it revealed screenshot photographs of conversations. Screenshot photographs. This is interesting. Screenshots between Mitch and defense counsel Andrew Baldwin, wherein they candidly discuss the Richard Allen case. So why would you have to see screenshots of it? You know what I mean? Why isn't that information just there? Why isn't that candid conversation in text just available? Why are they referring to screenshots? I just think that wouldn't you just have the wouldn't you have the conversation? Why are you talking about screenshots in the iCloud? Can't you pull up in the iCloud the conversation between those two people? And it says that, Mitch and defense counsel Andrew Baldwin, wherein they candidly discuss the Richard Allen case and candidly talk about the court and the state displaying a free flow of information that is protected by the court's gag order and the order protecting discovery. Now, again, I think the only thing that's interesting for me with that is, so you went through this person's photos, and in these photos, you happen to come across where Mitch at one point decided to take screenshots of his conversations with the defense, right? So let me ask you this then. Normally, if you take screenshots of something like that, it's to disseminate even further. So who did Mitch give those screenshots to? Did he give them to the prosecutor? Was Mitch a double agent? For there to be screenshots in somebody's photo reel, okay, why are you taking screenshots? Who are you giving those to? Why would you need those for yourself? Okay, it's in your shit. Yes, Miss 100. I also believe that he was a consultant, so that would have to you'd have to look into that. I mean, but I find it interesting that Mitch would be taking screenshots of his conversations. Was he taking screenshots of other people's conversations? Did they find that was that like a normal practice of Mitch? You know, normally when you take screenshots of someone's conversation with somebody, you're sending that to another party. Also, when was the screenshot taken? So let's say if me and Miss Potts here, we have a conversation today, and let's say that then 2 months go by, and I'm like, you know what? I'm gonna scroll back through me and Miss Potts's text messages, and I'm gonna go back and I'm gonna go find something that I'm looking for, and I take screenshots 2 months later of our conversation. So I'm curious on when the screenshots were actually taken of the conversation. What is the date behind? And there's going to be metadata behind that. Or was it taken, or were the screenshots taken like that day within just a couple seconds of the conversation? Do I think that that matters? Absolutely, I think that matters. Because what was the motive behind taking the screenshot in the first place? So that the investigation shows that the defense counsel, number 22, failed to secure evidence and discovery materials in this case, specifically graphic crime scene photos, which were then distributed to the public and put on the internet in violation of the court order dated February 17, 2023. And evidence supports a conclusion that the disclosure was ongoing. What are you saying that as far as like the defense failed to secure evidence and discovery materials in this case, specifically graphic crime scene? So the same person that was taking screenshots of Baldwin and his conversation is then the same person that is taking pictures by theft, unbeknownst to Baldwin, that this guy was taking pictures when he was at his office of crime scene photos. Right. Because who does the leak help? How could the leak possibly, you do all that work for the Franks hearing and the motion, right? You do all that work, you're busting your ass, you're not saying a word, and the leak you think is going to help who? It's definitely not going to help the defense. That's the leak. How can that possibly help the defense? This is his investigation, though. This is why he wasn't working on his murder, because he wanted to find out who was behind this leak. If the investigation shows that the defense counsel failed to secure evidence, okay, that on October 19th, and again at the hearing held on October 31st, David Hennessy, attorney for Andrew Baldwin, suggested to the court that both attorneys be sanctioned for their actions. Those sanctions have yet to be addressed. Now he wants to use David Hennessy against his client. Oh, so shit. That the state was notified in the beginning of the leak Rossi said it best. There were leaks before we ever even took this case. There's been leaks for 5.5 years. That the state was notified in the beginning of the leak by the defense, by the families of the victim. That the state was notified in the beginning of the leak by the defense, by the families of the victim. Since that time, the state has had an opportunity to talk to the families of the victims about the photos and information that was leaked. The amount of harm and re-victimization that has caused the families of the victims is unmeasurable and incurable. So this whole time I'm saying if I was the family, I would be praising these attorneys for trying to get to the bottom of who truly was responsible for killing my granddaughter or my daughter. You know, I'd be praising their work because I want the truth and nothing hidden, right? Nick McClellan is saying that. So let me ask you this then. What did they think about David Erskine and when he went out there in those text messages about him saying that how Abby and Libby were found and about the R word? What about the stepbrother, okay, of one of the victims putting that shit out there in text messages to friends? And he was one of the people that found, was with the search and rescue crews. What about that? Why is anybody talking about that? So did this guy, he was just lying, or was he trying to hide the fact of what was truly there to hide Odinism? But David Erskine was basically by marriage. I think it was like a step uncle of, but Anna lived with him. Abby was around him all the time. So what are we going to do about that? Well, what about that leak that has, you know, why would anybody talk about their niece like that with anybody? It's fucking sick if you ask me. But hey. Okay. Number 25. That the press release and the 2 occasions of leaked information shows a trend. These are just some trendsetters. A trend by defense counsels Brad and Andrew of not being completely honest with the court, violating the court's gag order set in place. I think when you go back to number 21, though, this whole iCloud of Mitch's, why do you have screenshots? Revealed screenshot photographs of conversations between Mitch and defense counsel Andrew. Well, hopefully they did enough of an investigation to see if those screenshots were in fact between Mitch and the defense. Number 1. Number 2, when they were taken, why they were even taken. But this just shows somebody that was. Why are you even taking a screenshot of that? And why aren't you just, if you're going to the iCloud, why aren't you going and getting their the actual messages? Sinclair says, if you're going to set rules, all have to abide by them. This isn't a cafeteria court where you pick and choose what rules you follow. I just can't believe how much attention is being given. These were all things that were going to come out at a trial. But you would think that you'd be putting your time towards prosecuting the murders of these two girls, and that this wouldn't be what you're putting your time towards. That's bottom line to me. I just, and we know how they investigate. So I like fucking screenshots. Why is Mitch taking screenshots of his own messages that he would have? Unless I plan to disseminate them. Who did you give those to? Who did Mitch take those screenshots and provide that to? And do you think Baldwin knew that? If I trust somebody and then they fuck me, I mean, what the fuck? How was that on me? Especially if I'm using a consultant with my case. I don't think it's grounds to kick anybody off of a case. Sneaking in the chat while working. Oh, yeah. You know, you only screenshot something because you want to save it, show it. Yeah, and there should be a paper trail just to know when it was. I'm telling you, was that screenshot right away, or did this person go back in time to go get it? You know, if you're keeping an eye on Baldwin and Rossi and you're paying attention on who's going in and out of their office, okay, then when you want to do a shakedown of somebody, it's like, okay, here, let's compromise this person. Let's see if he can get this. We'll have this leak so that we can kick him off the case, okay? Because they're way too close to what has truly happened. But if you have all the goods against Richard Allen, none of this fucking shit should matter, right? None of this should matter. You have your guy. You're muddying the waters. Go prosecute a murder. It's very similar to when I look at like the Karen Reed case and all this stuff with Turtle Boy. They did all this stuff with Turtle Boy, and now you're telling me, because I'm going to talk about it, is Karen Reed's phone, 2 phones were taken, and now it's coming out that Karen Reed and Turtle Boy have over 40 hours of communication on a phone, okay? And that they were able to obtain this type of a search warrant because they were looking into her for conspiring. This is what I think everyone, when people laugh and like, Lana, you're a conspiracy theorist. No, bitches, they are. They are. The state's over here saying this is a conspiracy. Look over here. Look at the Karen Reed case. Turtle Boy is conspiring with all these people to witness intimidate. The state, they're the ones that are talking about conspiring. But it's okay if they talk about it. But the moment that we talk on the opposite end of it, we're conspiracy theorists, the fuck out of here. No. Conspiring with another person to commit a crime, whether or not you go and commit that crime, it's a crime all on its own. It holds its own fucking charge, you dumb fucks. Okay? Conspiring is a criminal offense, whether or not you do anything with it. If you at any point conspired with somebody to go and do something, whether or not you do it or not, whether or not you're successful, you are 100% guilty of conspiring. And conspiring is a criminal offense all on its own. That's like conspiring to commit murder. So I just laugh when people want to talk about, oh my God, everything's not a conspiracy. Well, fuck it. Look at us right now. We're not the ones that are saying there's a conspiracy. It's the opposite way right now. The state's all like, blah, 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 blah. But this is what they're doing with their time. Instead of, I get it. They're going after a record. They want to put a record on. They want to establish their record so that stuff can start happening. Well, maybe y'all should have thought about this months ago. Okay. You thought you could do it the back way, Indiana way. And you couldn't. So now they're putting together this record. And that's all that I see is them putting together this record. But it's interesting when you truly look at number 21 on this for contempt. 21 is very interesting to me. And I think that people should really think about that. The iCloud had screenshots. Okay, when were the screenshots taken? how long after the conversation was had between Baldwin and this person did this person go back and take the screenshots? And then who were the screenshots sent to? Period. And it tells me that if you don't have any more information, that means you don't want to talk about this part of it, because everybody knows why you take screenshots. And you take screenshots, that's disseminating it, and you're doing it for a reason. And it's usually to pass the information along. So who did Mitch pass that information along to? But more importantly, what was the date behind the screenshots? Period. But I noticed that they didn't talk about it anymore. So that's not, they would talk about it if it helped them. But hey, let's have a hearing about it. And then didn't Mitch put a affidavit in? So it should be interesting to hear what Mitch has to say about the whole fucking thing, you know? And then I want to show, you know, Gull's picked replacements came out on court TV and said flat out that they believe that Richard Allen is innocent and that Odinism is real and it's alive. And hats off to, you know, Baldwin and Rozzi, because at first I thought it was this hocus pocus shit. Holy shit. No, I'm wrong. Hats off to them and the work that they did for their client. So, and I think what's interesting is that he got permission from Gull to speak publicly when there's a gag order. She shouldn't even be, wow. That tells me that she thought maybe he wasn't going to say what he was going to say. Why would she ever allow him to speak if she knew, in fact, what he was going to say? So I don't know. You know, I don't know. But why is she even letting him? Why do you even need to go get permission? I don't think that I think that that shouldn't have even been allowed. Even though I love what he said, I just still don't think that that should have been. Why did she allow that? There's a gag order, and those were his attorneys at, you know, for a period of time. So for my, it's just crazy to me. Well, hopefully that bit her in the ass though, because what he had to say definitely did not help the prosecution one bit. So if you guys want to stick around, I have a live at noon, but I'm going to be squeezing in here here at the tail end. I want to show you guys something. We're just going to ignore the fact the DA has the defense attorney work product and boldly mentions it in this. Not at all. I think they're idiots. I think Nick's a fucking moron. But the question is they obtained a search warrant. How did they obtain a search warrant for that? Like, for what? Because of a leak? I want some stuff done on David Erskine's phones. I want a search warrant on his fucking shit, you know? I want a search warrant on, fuck it, the Patties. Let's go. Let's go get their iClouds. Let's go see what the fuck's going on over there. You know? Like I said, the focus isn't on the murder case. And that to me is just mind-blowing. Like, just absolutely fucking mind-blowing. Want to mention Brandon Woodhouse over here. Brandon Woodhouse put it on his YouTube channel. Look at this. They accidentally sent an email, right? But God, you guys are fucking bastards because you didn't tell us that you accidentally sent this. Instead, this leak of information was not discovered until the state uncovered it on Brandon Woodhouse's YouTube channel. Look at YouTube just getting nothing but play up in this motherfucker. Further, it was discovered that Brandon Woodhouse has disseminated the information to several other people, and his YouTube channel was viewed by multiple viewers. Yeah, he was also talking about the way that Nikki Poo Poo abused him. Isn't that the same kid that Brandon Woodhouse was being abused in there? Yeah. Let's not mention that, though. Then on February 13th, you guys, the state filed a motion requesting a protective order governing discovery in an effort to prevent the defense from disseminating evidence in this case to people outside the case and or to the public. The court granted the state's motion. Okay, now, so this is why I think it's important about this date. Okay. They asked for this to happen on this date. Did Mitch take his screenshots before or after these dates? That's what I would want to know. Because also the search warrant for the iCloud, what dates were you specifically going for with this? You have to say what you're specifically looking for. You have to be specific. Okay. And yeah. Those are screenshots. Screenshots. October 18th was Mitch's submitted affidavit to the court stating that he, in fact, went into the conference room of defense counsel Andrew Baldwin and took pictures of discovery evidence without the permission of defense counsel Baldwin. That the investigation were able to retrieve messages between Robert and another individual that showed that Robert had detailed real-time knowledge about when evidence was submitted to the defense, and that the contents of that evidence for weeks before the photos were leaked. Fortson also knew the actions defense took in trial preparation, leading law enforcement to believe that this was not a one-time act of one person, but a consistent leak of information and discovery in the case, or betrayal, or absolute betrayal. You know what absolute betrayal is? It's not a leak. You know what the word betrayal is? Betrayal isn't that you leaked some fucking information out into the internet. Betrayal is when you backstab somebody to the point of almost like I was saying, like a double agent. That's really weird. It's really weirdly written too. That investigators were able to retrieve messages between Robert and another individual. I think this is almost like revealing when the screenshots would have been taken, because it would have a date on there. That's how Robert would have known. Interesting. Mrs. Smith says, if Nick isn't removed from the case and a special prosecutor appointed, the entire state of Indiana should be at the courthouse demanding it. This is, yeah, it's crazy to me. Sherlock Kendra says, you get a warrant on the Patty's phones, it would be solved. But I just can't believe no one wants to know about that timeline. I want a hearing. I want Mitch to have to talk about this. I want a hearing for that. That's what I want to see. I want to see that. But they're just creating this record. They're putting stuff on the record. Jeez. 1 second here. I want to share. Let's see. Where's it at? Mm-hmm. Okay, here we go. I'm going to share this.
In the high-profile case involving Karen Reed. She is the woman on the left side of your screen. She's charged with killing her police officer boyfriend, John O'Keefe. On the right is Aiden Kearney. He's a controversial blogger known as Turtle Boy, and he claims Reed is being framed
This
in
is
an
all
elaborate
new.
cover-up involving law enforcement. Thanks for joining us tonight, everybody. I'm Corey Smith.
I'm JC Monahan. Now, fast forward to today when NBC 10 received new documents that show Reed and Kearney have had numerous conversations and that Reed fed him private information about her case. NBC 10's Michael Rosenfield joining us live from Norfolk Superior Court in Dedham to explain what's going on with this. Michael.
JC, this has been a highly unusual case from the very beginning, and now it's taking another interesting turn. All of the new information we've been learning today coming from these court documents filed here at this courthouse in Dedham. In the high-profile Karen Reed case, a new twist. Court documents allege she has been feeding confidential information to well-known blogger Aiden Kearney, who goes by the name Turtle Boy online. Reed is accused of running over her boyfriend, Boston police officer John O'Keefe, 2 years ago and leaving him to die in a snowstorm outside a home in Canton. Her lawyers say she's been framed and Kearney has taken up the claims. According to the state police affidavit, investigators believe Reed sent Kearney information about witnesses, like home addresses and pictures, autopsy photographs, crime scene photos, pictures of her car, and the 911 call made when her boyfriend's body was found.
This is a unique case.
Ken Mello is the special prosecutor brought in to handle allegations of witness intimidation connected to the Reed murder case. Kearney is already charged with witness intimidation, and now Reed could face similar charges as well.
This is all part of an investigation regarding the intimidation of witnesses. So if the evidence shows after we review everything that there was intimidation, either by way of conspiracy or otherwise, that would be a criminal charge.
Court documents indicate Reed and Kearney communicated via intermediaries and the messaging app Signal, and also directly with 189 phone calls totaling more than 40 hours.
This is a serious breach of the court's rules.
Legal analyst Michael Coyne says a murder defendant sending non-public information about the case to an influential blogger would be highly unusual.
That's an awfully significant turn of events and may well mean that Ms. Reed is likely going to face additional criminal charges before this case is over.
Exactly, you guys. They're going to go at her with conspiracy. So everybody's going to talk about, oh, you're such a conspiracy theorist. Da, da, da. Here we go. This is conspiring, y'all motherfuckers. Listen up. I think Karen Reed is 100% innocent. I think this is going to be so interesting, but this is all new. But how they even obtain this, okay? I don't think that this should have ever been able to be obtained, and it should be fruit of the poisonous tree, in my opinion, because of these fucking bogus ass charges against Turtle Boy is what led them to saying that they could obtain two of Reed's phones, two of her phones, and that within, I'm curious to see what Alan Jackson has to say about this. You know, just because I think Reed is 100% innocent, which I do. I have my opinions on Turtle Boy. I think he definitely got her case in the limelight where it needed to be. And then you kind of just like let it kind of stay there, you know? But it's just going to be interesting because they can say whatever they want until there's going to be, now her attorneys are going to say whatever, but they put in an affidavit that there was 40 hours of communication between her and Turtle Boy. And of those 40 hours, it consisted of 189 different calls that they communicated through an app called Signal, and that they used a third party to first they used a third party to communicate at first. Now, I would love to know the dates and the times of these phone calls, third party messaging as like a go-between with this other woman. Only reason why is because I can't imagine that when Alan Jackson would have joined the team, that this would have been going on. Alan Jackson's pretty by the book. We have firsthand knowledge of his pretty by the book, and so this doesn't come up. This does not get revealed. Unless they arrest Turtle Boy and are charging him with everything, and then somebody's over there granting these search warrants, granting things to be taken in. So this doesn't negate the fact, in my opinion, that she is 100% innocent. I think this was a woman that was trying to do everything she could to, you're facing murder charges. You're being framed, but this is now the new thing that they're going at with Turtle Boy and Karen Reed. So I think we have two cases that are very similar, yet the crime was different, but the way that they were investigated and went about in terms of framing and in corrupt areas. So Karen Reed case and the Delphi case, in my opinion, have a lot of similarities.
I have reached out to the attorneys for Karen Reed today, but so far I have not yet heard back. Her murder trial is set to get underway here at this courthouse in Dedham in March.
See, this is all just crazy to me. Again, if you're just joining.
And we begin this Wednesday night with a new twist in the high-profile case involving Karen Reed. She is the woman on the left side of your screen. She's charged with killing her police officer boyfriend, John O'Keefe. On the right is Aiden Kearney. He's a controversial blogger known as Turtle Boy, and he claims Reed is being framed in an elaborate cover-up involving law enforcement. Thanks for joining us tonight, everybody. I'm Corey Smith.
I'm JC Monahan.
Also, it should be known that in this case, there is no gag order. So Karen Reed, her case, there is no gag order. Now, if there was protective orders on certain things, and I don't know what is or what is not.
Now, fast forward to today when NBC 10 received new documents that show Reed and Kearney have had numerous conversations and that Reed fed him private information about her case. NBC 10's Michael Rosenfield joining us live from Norfolk Superior Court in Dedham to explain what's going on with this. Michael.
JC, this has been a highly unusual case from the very beginning, and now it's taking another interesting turn. All of the new information we've been learning today coming from these court documents filed here at this courthouse in Dedham. In the high-profile Karen Reed case, a new twist. Court documents allege she has been feeding confidential information to well-known blogger Aidan Kearney, who goes by the name Turtle Boy online. Reed is accused of running over her boyfriend, Boston.
I think the only way that you could say anything was confidential information is if that would be protective information. Confidential information is protective information, and there would have to be a court order protecting that information.
Police officer John O'Keefe 2 years ago, leaving him to die in a snowstorm outside a home in Canton. Her lawyers say she's been framed, and Kearney has taken up the claims. According to the state police affidavit, investigators believe Reed sent Kearney information about witnesses, like home addresses and pictures, autopsy photographs, crime scene photos, pictures of her car, and the 911 call made when her boyfriend's body was found.
This is a unique case.
Ken Mello is the special prosecutor brought in to handle allegations of witness intimidation connected to the Reed murder case. Kearney is already charged with witness intimidation, and now Reed could face similar charges as well.
This is all part of an investigation regarding the intimidation of witnesses. So if the evidence shows after we review everything that there was intimidation, either by way of conspiracy or otherwise, that would be a criminal charge.
Court documents indicate Reed and Kearney communicated via intermediaries and the messaging app Signal, and also directly.
Let's see if we can pause it right there.
Reed and Kearney
is intended for use or has been used by means of committing a crime. Any mobile device capable of communicating and cell phones used by Karen Reed. Seizure only, no search of data as outlined in affidavit. The data on any cell phone seized be copied, provided no search of that data will be done absent further warrant or order of the court. So all they did was seize her items so that she could not, I guess, dispose of them.
Communicated via intermediaries and the messaging app Signal, and also directly with 100.
And let's see if I pause this on the money right there.
Investigators believe
I, Detective Lieutenant Brian Tully, am a Massachusetts State Police officer. Have been a police officer since 2006 to July 2012. I was also assigned to the Norfolk State Police Department. Based on information contained in the numbered paragraphs below, which are product of my own investigation. Okay. During the investigation, testified Matthew, B. Jennifer, C. Brian, D. Julie Albert. Interesting. In order for there to be witness intimidation, these people have to be labeled as witnesses. That's interesting to me. Well, I'll see if I can get my hands on the full affidavit, but I just wanted to close out with that. And join me back here at the top of the hour, noon, as I'll be discussing a little bit of the Kansas City case mixed with the Idaho 4 case. Appreciate you guys joining us, and see you next time.